Yes, Mr. Manley.
If it pleases your lordship, your ladyship, I was about to take the court to the credit hire cases, and the first of those is the case of Farrell and Birmingham City Council, which is page 388 of the Authorities Bundle, tab 15.
Thank you. Yeah.
So that's a decision of this court from 2009. It's an appeal from a non-party costs order that was imposed. As it happens, the costs order was imposed against DAMS, Direct Accident Management Services Limited, by His Honour Judge McKenna in November 2008. There are some aspects of the facts which are material, or may be material, to what I and the respondents have to say about this. So if we could come, please, to page 390 in the judgment of the Chancellor, Sir Andrew Morritt, starting at paragraph 2. So there were two individuals, Mr. Farrell and Mr. Short, who were involved in the car which was struck by a bin lorry owned by the council. There was a period of hire, which we can see further down paragraph 2, and the terms of the hire were set out towards the end of that part of the paragraph before we get to the quotation from the material terms in a hire agreement and a form of authority. There was a material provision in the hire agreement which we have set out, which was clause 5. In not on conventional terms, subparagraph 1 was the deferment of the hire charges, subparagraph 2 was a right to pursue an action in the hirer's name, and subparagraph 3 was the right to pursue an action in the County Court or High Court, and an obligation to cooperate in the action and attend any hearing. What then, in fact, happened, there was a pre-accident value, as we can see in paragraph 3. So there's a claim for hire, there was a claim for pre-accident value, and at paragraph 4, the individuals entered into a CFA with a firm of solicitors. There were also, in the background, two collective conditional fee agreements. So those are the agreements where somebody providing funding for claims does so on a sort of global basis for a whole category of claims with a particular solicitor, and they were between DAMS and the solicitors and its successor firm, Armstrong's. They referred to DAMS, as you can see, as the funder, and they also provided the last sentence of paragraph 4 that DAMS would be jointly and severally liable for the costs and disbursements and could have been called on to pay the adverse costs, although the expectation was that they would be covered by after the event insurance if the claim was unsuccessful. The claims were not limited to credit hire. If we look at paragraph 5, the PAV, pre-accident value, was paid before any commencement of proceedings, but there was a personal injury aspect to the claim, so medical reports were produced indicating minor injuries for both claimants. So again, a not unconventional, not uncommon pattern. Proceedings were then issued, claiming damages, and the special damages are set out towards the top of the next page. And then what happened, and this is the slightly unusual aspect, the council sought to amend its defence and allege fraud, and it pleaded a counterclaim for the return of the pre-accident value. In consequence of that, eventually, and on the morning of the trial, the claim was discontinued. The counterclaim proceeded and was made out, and they were ordered, the two individuals were ordered to repay the pre-accident value, and they were ordered to pay costs, which, as we see at paragraph 7, of course, were not paid. Therefore, we get to the non-party costs order application. That non-party costs order application, just to be clear, 4th and 5th line down in paragraph 7, was for the costs of the claim, not of the counterclaim. So it was the costs of the original claim as pursued up to the morning of trial, but not of proving the fraud as against the two claimants and of recovering the £9,300. If we then come down to paragraph 8, evidence was provided it doesn't seem to have attached much weight, and I'm going to pick it up halfway through that paragraph. This is recording what the judge decided. First, he concluded that the evidence of Mr. Bailey, who gave evidence for DAMS, couldn't be accepted as entirely accurate because he was an committed advocate for DAMS. We don't really need to worry too much about that, save that it's the first finding that the judge made. Secondly, this is much more relevant, DAMS' business was directed to pursuing the higher costs by proceedings, and DAMS was in a real sense the instigator of the litigation. He found that DAMS had controlled the litigation and stood to benefit, and he considered therefore that there was a case for the exercise of the discretion and ordered 80% of the cost of the claim to be paid by DAMS.
Yeah.
There was an appeal. Indeed, it was Mr. Williams who appeared on the appeal for DAMS. And we can see, starting at the last 3 lines on that page and over onto the next page, the contentions that were made by DAMS on the appeal. I'm just going to pick them up towards the top of page 392. Firstly, it was said DAMS wasn't a party to the fraud. Secondly, it was said DAMS' commercial interest in the case didn't exceed 20% of the value of the fraud. That's because, perhaps slightly unusually on the facts of that case, the credit hire was not the dominant financial factor. In fact, it was the pre-accident value that was the dominant financial factor. Thirdly, the commercial interest of the claimants was greater, amounting to 80%, which is a mirror of the previous point. And the fact it had been paid out before the action was commenced was irrelevant. Fourth, DAMS didn't either fund or control the litigation, since that was done by the solicitors. And fifth, DAMS, and this is a causation point, did not cause costs to be incurred. The costs were incurred because of the fraud of the claimants. And then sixth, which I mentioned earlier, doesn't seem to crop up very more. There was a point taken about lack of or inadequate notice. And then seventh, if DAMS, then why not solicitors or the after the event insurers? The next part of the judgment deals with the point about notice, which I'm not going to delay with.
Can I just ask a question about the reference to the funding by the solicitors? Presumably that's because what that means is they were doing it on credit.
I don't think it necessarily went that far. I think it meant simply no more than that there was a conditional fee agreement between the claimants and the solicitors, and therefore it was being funded. That was how the litigation was being funded.
I see. Thank you.
So then we come over the page, or if we could come over the page, please, to page 393.
Yeah.
Paragraph 14, and this is the reasoning in the judgment. It's a very short judgment.
Paragraph 14 is where he accepts that DAMS not being a participant in the fraud, but doesn't accept the other submissions.
Exactly so, my lord.
And goes through each of them to explain that.
Yes.
Yeah.
So the important part of those are, firstly, so the third line down, the first sentence beginning first. So the documents, in particular clause 5 of the hire agreement, demonstrate that the initiation and prosecution of the claim were direct consequences of the hire of the Nissan Primera by DAMS to Mr. Farrell. And we say that whilst there are some differences in the terms, in practical terms, that is the same position with both of the cases before you.
Yeah.
Second, the judge concluded, and of course the Court of Appeal is agreeing with these conclusions, that DAMS was in a real sense the instigator of the litigation. That conclusion was amply justified, and that seems to me to follow from the first conclusion. Second, the claim was prosecuted by the solicitors in the names of Mr. Farrell and Mr. Short at the behest of DAMS, because that is what clause 5 of the hiring agreement provided. So in other words, clause 5 of the hiring agreement provided, you must bring an action to recover these costs and cooperate in the pursuit of that action. Even insofar as DAMS left it to the solicitors to get on with the claim, so that's the point that the hiring agreements commonly provide, that the lenders can appoint solicitors, but they don't always exercise that, because what tends to happen is that the claimants appoint the solicitors that have been suggested to them, rather than them having to be appointed by the credit hire company. So even insofar as DAMS left it to the solicitors to get on with the claim, that is not inconsistent with the control of litigation by DAMS for which the hiring agreement provided. Interestingly, it's only now they come to any question of funding, and the court refers to the collective conditional fee agreements. And then if we come on down about 4 lines, it said they provided in terms that DAMS have been appointed to manage and pursue the claims on behalf of Mr. Farrell and Mr. Short. In the absence of any evidence to the contrary from DAMS, and natural inferences that proceedings were pursued and later discontinued with the knowledge and approval of DAMS. We'll come in a little while to see the inference that His Honour Judge Gargan drew in the Spectra case. And then at 15, they come to the question of funding. DAMS didn't, in fact, pay the solicitors from time to time. They didn't need to because the CFAs, which were plainly instrumental in the claimant concluding. Now, I entirely accept in this case we don't have collective conditional fee agreements. But I say that that is not the presence of a collective conditional fee agreement or some formal underwriting of the claimant's costs is not again a sine qua non to the making of a non-party costs order. It is an additional factor which leans in the favour of so doing, but its absence by no means means that a non-party costs order should not be made. And again, we can see on page 394, 5 lines down in the first paragraph, that the additional point that the Court of Appeal draws in relation to funding is that in addition, DAMS hired the Nissan on credit terms to Mr. Farrell. The hire was the essential catalyst, and that was funded by DAMS. And that is, of course, consistent with the position in these cases. So the Court of Appeal has concluded in practice that by virtue of the terms of the hire agreement, the credit hire company can be regarded as the instigator, the initiator, however you want it, of the claim, that it can be regarded as having a degree of control, that it was in fact funding, but also that it can be seen as funding because it provided the vehicle on credit terms, that was the essential catalyst, and that was what they were funding. The court then came to the question of quantum, having decided that there was nothing improper in the non-party costs order that had been made. Quantum, so the idea that the pre-accident value was substantially greater than credit hire, didn't alter their conclusion. They note, as you can see, that the write-off value of the vehicle had already been paid. The non-party costs order didn't seek the cost of recovering it through the counterclaim, and that the bulk of the special damages was in fact the credit hire claim. There was, of course, as we've already seen, there was a personal injury element to the claim. The fact there was a personal injury element to the claim doesn't seem to have been thought either by the judge below or by the Court of Appeal to be a significant factor leading to a different conclusion. Certainly, it wasn't thought by the Court of Appeal that it could properly be said, oh well, these claimants had a personal injury claim and some other aspects to their claim which weren't credit hire, therefore they would always have brought a claim, therefore the costs would always have been caused, therefore a non-party costs order could not be made. That forms no part of the reasoning. The court doesn't seem to have accepted Mr. Williams' point that the costs were in fact incurred by the claimants having brought a claim and having brought it fraudulently. So again, that was part of the causation point. It was the claimant's claim. They were responsible for this fraud. That wasn't a good reason not to make the order. And indeed, from a causation perspective, and we say this goes to support our point that causation is just part of the overall justice, the Chancellor at paragraph 17 concludes not only was the order that the credit hire company pay 80% of the cost of the claim unimpeachable, but in fact that it would possibly have been open to the judge to have awarded 100% of the costs of the claim. There cannot be any basis on which either of those awards of either the 80% or the 100 would have stood if it had been correct that the Court of Appeal had to disallow any costs which it could be said would have been incurred because the claimants were bringing a claim anyway.
Yeah.
So that conclusion cannot stand with the respondent's analysis of causation, we say. So, whilst of course the facts of this case are different, we say the core reasoning in this court's decision in 2009 is consistent with our case, both as to identifying a real party, and again in this case it couldn't be said that the fraudsters, Mr. Farrell and Mr. Short, weren't real parties. They plainly were. But that wasn't a bar to identifying the credit hire company as a real party, and secondly, as to causation. Lord, that's this court. Can I then take the court to the extent it assists to 3 first instance appeals?
So that's the only credit hire case in this court?
That's the only credit hire case in this court.
Okay, yeah. So 3 first instance cases, yeah.
And then I'm going to come to another case of this court which wasn't a credit hire, but where there's an issue raised as to the question of a non-party cost order. So the first of those cases is the decision of Mr. Justice Turner, 2 of the cases of Mr. Justice Turner, tab at page 502 of your bundle. Sorry, I've got my tab number wrong, obviously it can't possibly be tab 2.
502 is me.
502 is me.
Tab 23.
Tab 23. I'm missing a 3 off the end of my numbering. Thank you, my lord.
Yeah.
My lords, my ladies. So this is the case of me against Jones, or really against Select Car Rentals Northwest, which was the credit hire company in that particular case. So again, I don't want to delay too long on the factual matters. What's more of interest is the analysis of principle. But if we can come to page 509.
Yeah.
So this is dealing with the point about CPR 4416. So this is the authority that in fact is cited in the White Book for the proposition that CPR 4416 and the practice direction don't create a separate discretion to make non-party costs. They're just reflective of the non-party cost order jurisdiction. I don't dispute that. It's not disputed by the respondent, but I just highlight it for your lordship's attention. So that's dealt with over the next page, and the conclusion. If I can then take you on the court on to page 511.
Mm-hmm.
So this is dealing with the question now of financial benefit. Paragraph 32. And this is dealing with this through the prism of what we've seen in the 4416 and the practice direction, claims made for a financial benefit of another. Just below letter B, Mr. Justice Turner disagrees with District Judge Avent in a different case and his interpretation of what is or is not a claim made for the financial benefit of a non-party. In a conventional credit hire case, the claim for the hire charges will be made for the financial benefit of the credit hire organisation. In this regard, the practice direction, in my view, amounts to little more than a statement of the obvious. The party making the claim for costs against a credit hire organisation doesn't have to prove the actual agreement was a profitable one, as the district judge appears to have held. The financial benefit is made out because, however good or bad the original deal, is to the financial benefit of the credit hire organisation to recover the monies due under the hire agreement through the process of the claimant's litigation. Some money is better than no money. And we would endorse that observation. Over the page at page 512, paragraph 39, coming back to that point and to the practice direction, the judge concludes that the fact the practice direction categorises a claim for credit hire as such is uncontroversial, but makes the point that that doesn't give rise to a separate discretion. The next point we draw assistance from is paragraph 41 on that same page.
So you say 39 is right.
We say 39 is right.
It doesn't give birth to the practice direction, doesn't, as it were, give some enhanced or different approach.
No, it's reflective of
The
justice that the rule makers perceived would apply in those sorts of cases when an application for a non-party costs order was made. But
so the application of the Cox regime makes no difference.
It makes no difference at all. Indeed, if anything, we say that the Cox regime is a helpful pointer. It indicates where the justice is likely to lie. If a claimant has brought a claim where part of it can be seen to be for the financial benefit of a third party, the Cox regime, 4416(3), points firmly to the idea that the justice in that situation, if the claim fails, lies in making the third party pay the costs.
Yeah.
My lady, my lords, I was going to come to paragraph 41 because this makes a point that we're going to see echoed in the DAMS case in the judgment of the district judge. So this was the argument that was advanced on behalf of Select, that the terms in the credit hire agreements are essentially standard business practice. Now, I've already made the point about exceptionality, but the point was made here by Mr. Justice Turner, whose judgment will carry rather more force than my submissions, I hope, just below letter D. Even if these terms and this practice are to be taken as standard in the industry, this doesn't provide Select, or for that matter any other credit hire company, with immunity. To find otherwise would be to reintroduce the concept of a narrow requirement for exceptional circumstances, firmly rejected by Lord Brown in Dimmock, which we have already seen. And then over the page, at page 513, there's a summary of the judge's conclusions. So 1, 4416 doesn't introduce a bespoke and distinct discretion. We entirely agree and respectfully submit that that's correct. Number 2, the wording of 4416 is entirely consistent with the way the proper approach to the discretion toward a cost against non-party has developed. Again, we would submit that that's entirely correct, and indeed, for the reasons we've given, operates as a pointer to what is likely to be just. Sub 3, the practice direction, insofar as it provides that claims for credit hire are made for the financial benefit of a person other than the claimant, is uncontroversial and requires no artificial interpretation to save it from being ultra vires. Number 4, the fact that any given credit hire organisation's connection with the claim is no greater than is commonly the case does not without more provide it with an automatic immunity from a non-party costs order. So the appeal against the non-party costs order was dismissed.
Yeah.
So that's the first of the cases. Can I then take your lordships and your ladyship to the case of Amjad, which is tab 28, page 667, which is a decision of Mr. Justice Ritchie. So that's tab 28, page 667. So just again to introduce this case relatively briefly, this is not an application for a non-party costs order. This is a case involving credit hire where the claim was partly successful but the credit hire claim essentially failed and therefore the claimant didn't better a Part 36 offer. And it's a case where the defendant asked the court to disapply quotes to allow it to enforce against the claimant. And its relevance, or what we say is its relevance, as we will come to see, is that the judge, Mr. Justice Ritchie, analyses the relevant rules and essentially concludes that in a case of that kind, where it is concluded that the relevant part of the case was for the financial benefit of a third party, the court should not usually disapply quotes to allow the costs to be enforced against the claimant, but rather the defendant should consider an application against the non-party for those costs.
Yeah.
So just to pick it up very quickly by way of the facts, page 670, paragraph 2, letter G. So we can see that in that paragraph, the summary of the credit hire claim with a total bill of £51,000 odd, repairs of 5,200 odd, recovery costs of 3,200 odd, and a final award for the totality of the claim of £10,000 odd. No, £10,000 exactly, in fact. If we can then, we kind of have to come on to page 674. Paragraph 15, so the judgment was entered for the sum. There was a Part 36 offer for £5,000 or so more. Claimant had failed to beat it. And then at letter H, the judge granted permission to the defendant to enforce the cost against the claimant up to the maximum of £15,000. So £5,000 more than the damages and above the Quox cap. And that issue was then, the question was, could the rest, excuse me, the issue was the judge right to have allowed enforcement as against the claimant?
The claim beyond the Quox cap.
Correct.
So was the judge right to disallow the Quox cap?
Correct.
Disapply the Quox cap.
To disapply the Quox cap,
Yeah.
to give permission for enforcement beyond the level of the Quox cap.
Yeah.
So it was about the £5,000, not the 15,000.
My lord, yes. So the usual provisions under Quox is that you can wipe out damages, but you can't enforce.
Yeah.
Page 675, paragraph 17, just in passing, we can note the basis of the judgment. So there had, just between letters B and C, been an allegation in that case of fundamental dishonesty, which had been unsuccessful. So the claim hadn't been wiped out in its entirety. The claimant had succeeded, but in essence she lost on the credit hire charges, which was the largest part of the claim. The judge's reasoning...
And the losing part included credit hire strictly and also the storage.
Storage and recovery charges, my lord, yes. Paragraph 19 is the summary, is the judge's reasoning for lifting the Quox cap. And so he lifted it by reference to CPR 4416 2, and we'll come to see precisely what he did. So at E, he concluded that it was patently a case in which the claim was made for the benefit, in respect of a claim other than one to which the section applies, because it was a claim for credit hire. And equally, it's very likely a claim made for the benefit of a person other than the claimant. So those are the two limbs of 4416.2. One is a claim that's other than a personal injury claim, and one is a claim made for the benefit of another party. He concluded at G that in reality this was a case that in large part was about the credit hire, and therefore he didn't consider it unjust to make an order under 4416.2. Rather, justice called for an order to be made. And then, Lords, if we can come on, it's quite a lengthy judgment, but if your Lordships and your Ladyship will be kind enough to come on to page 689. 689.
Yeah.
So there, there's reference to 4416.2b. So that's the second limb of 4416.2, which is when a claim is made for the benefit of a claimant other than a claim to which this section applies. So that was the basis on which the judge ordered the lifting of the cap. And then if we come on another 3 pages to 692.
Sorry, and just to make sure I'm not misunderstanding.
No, sorry, Lord.
Putting it loosely, that's because the claim was for credit hire rather than for personal injury.
Correct. Part of the claim, the substantial part of the claim, was for credit hire, not personal injury damages. So there are two limbs under 4416. A claim that's essentially not a personal injury claim, which is 2b, or a claim for the financial benefit of another person, which is 2A. And so the order that was in fact made was made under 2B because the credit hire claim was not a personal injury claim. And what is core to the appeal and the analysis of Mr. Justice Ritchie was whether the judge should have looked at it as a claim that wasn't a personal injury claim, or whether he should have looked at it as a claim that was for the financial benefit of the other party.
Yeah.
At page 692, paragraph 58, the judge analysed the question of whose benefit that part of the claim was being brought. And at paragraph 58, he notes that in credit hire claims, in credit hire claims, the claimant can only recover damages if he has a lawful and sufficiently drafted contract so that he has a contractual debt to the credit hire company, which is recoverable from the defendant, albeit deferred. Therefore, by definition, the claimant has some interest in succeeding to alleviate that potential debt, and we would agree with that. However, the credit hire company has a far stronger interest in the success of the credit hire charges claim because all the money awarded will end up with the credit hire company. The whole of the financial benefit in money terms goes to the credit hire company. All the claimant will achieve, should the head of claim be awarded, is to be relieved of any residual liability. I bear in mind the claimant's liability is partly illusory because in most or many of such arrangements there's a tacit agreement that the credit hire company will not enforce against the generally impecunious claimant if the legal claim is lost. So here we of course know it's already been accepted in one of these cases that the agreement was de facto no win, no fee, and we say that that is the practice in general. We've already seen that the specific target market is impecunious claimants who are never going to be able to afford these. We've already seen in my respectful submission that one of the main there are really two aspects to the imposition of the liability. The first is to ensure recovery from the defendant, but the second is that it operates as an effective mechanism to ensure the cooperation of the claimant, which is the risk of the imposition of the liability. Continuing with his analysis as to who benefits, over the page at 693, paragraph 61, letter G, the judge considers the scale of benefit, who's benefiting in relation to these claims. And at letter G, he notes that at the other end is a claimant who's not paid the credit hire charges. And although stated as liable under the credit hire contract, that liability is or may be illusory or technical because the reason for choosing credit hire was the claimant couldn't afford to hire one at the basic hire rate. In my judgment, the correct interpretation of who benefits at this end of the scale is that this is an A case, not a B case. So by A case, he's meaning that it is a claim for the benefit of the third party. The award will go to the credit hire company if the claimant's paid nothing to the credit hire company. Despite passage of years since the vehicle was returned, the credit hire company hasn't enforced the charges or tacitly agreed not to, then there's no real benefit to the claimant in the claim for credit hire charges. Over the page then, at paragraph 63, he holds that in my judgment, because the two gateways are aimed at different people or entities, so one's aimed at claimants bringing claims for their benefit that aren't personal injury claims, the other's aimed at the claimant bringing claims for the benefit of a third party. The choice of gateway is determined by the issue of to whom the benefit goes. The who benefits test is generally binary and the court is assessing to whom all or most of the benefit is going. He doesn't say it's actually binary, but he says it's mostly binary. And then his ultimate conclusion, he allows the appeal. He finds that the judge was wrong to make a 4416(2)(b) order because under the two limbs of 4416, a credit hire claim is really brought for the benefit of the credit hire company. And then at page 708, he says this, between letters E and F, the CHC clearly would have gained the whole of the benefit of any award under the terms of the agreements. The only benefit the claimant would have gained would have been the eradication of his residual liability. Thus, in my judgment, the judge erred in making his tentative additional finding that B also applied. Once the gateway in A was open, so that's for a benefit of a third party, the court was empowered to look at making a non-party costs order against the credit hire company and would have been required to consider the case law that we have looked at. However, the judge was not asked to do so by the defendant and so did not. In my judgment, the judge was wrong then to lift the quote cap protecting the claimant using A. The court wasn't empowered to do so. I don't accept the respondent's submission here. The claimant should apply for an NPCO at this stage. So in other words, it was too late, in effect, either for the defendant to do so or for the defendant to recover against the claimant and say the claimant should then try and recover those from the credit hire company. So the appeal was allowed, but it was allowed on the basis, essentially, that analysing the principles underpinning credit hire claims, they should, as the rule and the practice direction indicate, be properly looked at as being brought for the benefit of the credit hire company, and if so, the target of the cost application should be the credit hire company, not trying to lift quotes in relation to the claimant. And we do say that's important because if our analysis is wrong, if these claims are not seen as being claims for the benefit of the credit hire company, then of course the practical effect is what you're likely to see. It's much more by way of applications to lift the quotes cap against the claimant under 4416(2)(a on the basis that part of the claim was not a claim for personal injury. And we say that would be unjust because the proper target is and should be the credit hire company. Lord, milady, can I then take you on to the next tab, which is page 713, the second decision of Mr. Justice Turner. So this is an appeal against an order imposing an 80% non-party cost order against a credit hire company. It's a relatively recent decision. There are, as there always are with these matters, specific factual aspects. They're set out on page 716. And in particular, and I won't delay by going through all of the details, but in short, the particular credit hire company here, Kinderton's, had essentially encouraged the claimant to bring the claim in ways which were thought to be less than satisfactory. So, for example, paragraph 10, the claimant was expressly told in the last sentence of the quote that he wouldn't have to pay for any hire or repair. At paragraph 9, it turned out, in fact, his car hadn't suffered any damage that would have made it unroadworthy at all in the first place. And at paragraph 11, the claimant was encouraged not to engage with attempts by the defendant insurer to give him a hire car, as opposed to hiring one on credit hire. The terms and conditions of the hire are set out at page 717, paragraph 13. And again, they all differ between credit hire companies, but deferment of obligation, right to appoint an external contractor, right to pursue an action in the hirer's name, obligation, little 4, to cooperate in the conduct of an action, and a default provision of termination of the agreement forthwith with repayment of the charges, again in another case of impecuniosity. So they all differ on their precise terms, but again are not dissimilar carrot and stick approach.
So where did you get the impecuniosity from?
My Lord, that's not in that paragraph. This was a case of impecuniosity. If your Lordship will give me a moment, I'll find an appropriate reference for it. I mean, we can see it in nothing else from the credit hire rate at paragraph 12, £345.08. So the claim, Lord Milady, so that the claim was pursued. we can see reference to the trial, page 719, paragraph 22. As it says in 23, it all went very wrong. And in fact, the damages, the collision had occurred, but the damages and high charges hadn't been caused. There was a finding of fundamental dishonesty and an order that over the page that the claimants pay costs. Obviously, quantity applied because of fundamental dishonesty, but again, unsurprisingly, they disappeared from view, and so we had a non-party cost order application. If we can then come, the order was made that the credit hire company pay 80% of the costs, and then there was an appeal brought, and if my lady, your lordships would be kind enough to come to page 723, we can see how Mr. Justice Turner dealt with the grounds of appeal, and you'll notice some similarity to the issues in this case.
So page
723.
Right.
So the first is that the appellant, it was wrong to conclude that the credit hire company had a financial benefit in the litigation, such as to found a non-party costs order. We can see Mr. Justice Turner's analysis at paragraph 39, and he refers therein to impecunious parties, provision of facilities, etc., etc., and then to the observations of Mr. Justice Ritchie, which he adopts, and at 725, paragraph 43, his conclusion that Kinderton's had a very strong financial stake in the litigation, and any benefit to Mr. Ibrahim in pursuing the claim for higher charges was all but illusory.
Mm-hmm.
The next issue is control, and we've seen already the points made, including by Lord Justice Coulson in the Gochner case, about treating the danger of treating matters as checklist. Similar point here by Mr. Justice Turner, paragraph 44. Danger that the concept of control is wrongly treated as if it were a traffic light governing access to the exercise of discretion. It's almost invariably a matter of degree. And then at paragraph 46, on the facts, there was a high degree of control. The contractual terms tied Mr. Ibrahim into bringing a claim and continuing it at the risk of incurring serious financial consequences in the event that he were to fail to comply. It matters little, if anything, that such consequences were not visited upon him. It's the threat and not the execution of the repercussions which forms the usual basis for control. And we would adopt that by reference to the terms of the agreements here. Page 726, the judge dealt with the question of causation. I'm not going to go all through it because it repeats a lot of the arguments we have in front of this court. But I'll pick it up at page 727, paragraph 54, where the judge notes a factual difference between the position of credit hire companies and liability insurers, which is that they involve themselves voluntarily, enthusiastically in claims after the accident. And then, to be fair to Mr. Justice Turner, at paragraph 57, page 728, he concludes 5 lines down that the judge wasn't obliged to make any specific finding of but-for causation, but makes clear that he's not intending to lay down any general rule about the making of non-party cost orders against credit hire companies. And then at the very bottom of the page, final sentence, an attempt mathematically to calculate on a but-for basis of causation would simply not have reflected the unfairness of allowing Kinderton's a free ride on the coattails of Mr. Ibrahim's claim. Paragraph 63 over the page, he deals with the arguments similar to the argument in Farrell, that in fact the cause of the cost was the dishonesty of the claimants, and he concludes, consistent with the conclusion in Farrell, that that wasn't a reason not to make a non-party costs order, that in fact the credit hire companies voluntarily assume that risk. And of course we've already seen from the DAMS documentation about the screening they go through and the nature of their business. So we say that the reasoning in that case is correct. It's consistent with the reasoning in both of the other cases that we've seen. It's consistent with the reasoning in Farrell, and it forms a pattern of reasoning which we say is consistent with the decision we invite this court to make. Can I just then deal very briefly with the case of Ali and HSF Logistics, which is the next case in the bundle?
Yeah.
This is in fact a recent decision of this court, including Lady Justice Davies, dealing with an argument in relation to a different argument in relation to credit hire, which is the argument that if the person hiring the vehicle hadn't had an MOT for their own vehicle originally, they shouldn't be able to recover the cost of the credit hire because essentially they've suffered no loss.
Yeah.
That argument was rejected by this court. That's not what we're arguing about today. That's not what we're dealing with, and of course that was correct. So what I understand the respondents to rely on is not that, but in fact the next tab, which is tab 744, which is that, and others in this room, including Milady and Mr. Williams, will know more about this than I, which is that in the consequentials for that matter, the appeal having succeeded, there is reference to the possibility of a non-party costs order being made. And then what is said, and as I understand what is relied on, are the reasons given in that case, for the cost orders that were made. And as I understand it in particular, it's the penultimate paragraph on page 746. The court has no information to suggest Mr. Ali was not interested in the outcome of litigation, and it would not be right for the court to speculate that DAMS or other person representing the credit hire industry was the real claimant. Now, I understand that that is in some way put forward to defeat our appeal on the basis that it's an indication of this court concluding that DAMS were not to be regarded as the real claimant. Now, in my respectful submission, but of course I'm cautious given the tribunal before me, that is reaching too far. We don't know quite what was said to the court, but at the very least what we do know was that there was not as far as I'm aware, a fully versed exploration of the issues in the way that this court has had. Well,
it wasn't a non-party costs order case.
It was all about the lack of an MOT and the unlawfulness. That's what the focus of this case was about.
Absolutely, milady, but as I understand it, this has been put in the bundle by the respondents, as I understand it, because it is some kind of indication that this court has considered whether credit hire companies are to be regarded as real parties.
Well, it's probably best if we wait to hear what Mr. Williams says about it.
I take it no further.
On the face of the order, there was an offer which was more than the claimant recovered, and that therefore, in the absence of anything else, this court decided, well, the usual rules should apply and the offer should apply, and that therefore the claimant was liable for those costs.
Well, Lord, I have no more to go on than what is in essentially the reason.
So I think for that, certainly on this point, you should wait and hear what Mr. Williams says about it.
I'm grateful. I may have committed the sin of attempting to preempt a point, so I'll respond if I need to in due course.
Yeah.
So, subject to one small point, that concludes the authorities. Can I then come, and I'll do it briefly, not out of any disrespect, to the judgments in both cases to explain where we say the judges went wrong.
Mm-hmm.
The first is the DAMS case, which is the decision of District Judge Jeffs of the 2nd of August 2023, which is at, or the relevant part starts at page 76 of the DAMS bundle.
Oh.
Paragraph 51 of the judgment. There is a more detailed critique of the judgment at page 39 of the bundle in my skeleton argument, starting at paragraph 72, which I rely on, but I won't read out for present purposes.
Yeah,
So
we take your skeleton argument, what you say about the judgment in your skeleton argument as read.
I'm grateful.
So these are just particular points. And we go to page 76.
Page 76.
Yeah.
So the first point is that the judge rejects the argument that the credit hire company, DAMS in that case, can be regarded as being the or a real party. And he does so, and again, I won't read it all out, but he does so on the basis, paragraph 52, that of course to recover the credit hire, the claimant has to have an enforceable liability to DAMS. Paragraph 53, he doesn't accept, therefore, that the claim was or was to be regarded as the claim of the hire company and not that of the claimant. And at the last sentence of paragraph 54, he accepts a submission that the claimant had either an exclusive or the primary interest in all aspects of the litigation. Well, that, Lord or Lady, either by virtue of the submissions I've made already, I've persuaded you that's wrong, or I haven't. But if it's wrong, then we say the judge is wrong. He rejects the argument that DAMS is to be regarded as a real party in very important or critical respects. Over the page at 62. He deals with the point by virtue of the evidence that DAMS do not make the decision whether to issue proceedings, they're not provided with copies, they're not informed about settlement strategy, they don't fund the proceedings, and that at the end they're informed about the outcome. But we say he ignores the points that are validly and properly made about the de facto control of the type that we've seen previously, and indeed we are told about by DAMS themselves in their documentation. At paragraph 65, he accepts the argument that the agreement is in commonplace terms and concludes 3 lines from the bottom that the stipulation in clause 5, which we looked at, is a commercial term and not a control mechanism. And for reasons we've already given, we say that that is wrong. At paragraph 75 and 76 on page 79, he therefore rejects the arguments that DAMS can be said to be the real party or satisfy the real party requirement. And then at paragraph 76, he says in any event that there's no causation because it can't be said that DAMS caused the cost to be incurred. Now, of course, on our case, he was essentially bound to reach that conclusion in any event, having gone wrong on the real party test. It's no surprise he concluded that insofar as causation was relevant, there was no causation.
Yeah.
Insofar as at 77, he applies some kind of but-for causation test, then for the reasons we've given, we say that that is wrong. That was a very quick summary of the reasons why we say the judge is wrong, but we respectfully say, no disrespect to the detail of his judgment, that the reasons why he's wrong either flow from what we've submitted on this appeal, or they don't, and the court either accepts our arguments or it doesn't. In terms of the Spectra decision, that is at page 94 of the Spectra bundle. This is the decision of His Honour Judge Gargan. It's a rather longer decision because, of course, it was dealing with our appeal on a whole range of matters. For present purposes, my lords and my lady, of course, a lot of what His Honour Judge Gargan did was agree with our submissions generally in terms of the approach to non-party cost orders, but then do us down by virtue of the good fortune point.
Yeah.
So I'm going to focus on the good fortune point, and I'll respond to any specific points made by Mr. Williams that I've not already covered through his respondent's notice, where he reopens them briefly at the conclusion. Just in passing, at paragraph 84 on page 111, he analyses the real party test.
Hang on.
That there can be more than one real party, so that's paragraph 84. We of course agree with him on that. Paragraphs 89 and 90 on page 113. He adopts and indeed considers himself to be bound by Mr. Justice Turner in his analysis of causation in Kinderton's, so of course we don't object to that aspect of his approach. And then when we come to paragraph 107 on page 118, he adopts the analysis of both Mr. Justice Ritchie and Mr. Justice Turner in terms of real beneficiary, and again, obviously, we...
Sorry, that's paragraph?
That's paragraph 107, my lord, page 118.
Yeah.
So, of course, all of that we agree with, and again, we can see that over the page, applied to the facts at paragraph 110 on page 119.
Yeah.
What we do disagree with it is when we come to page 130.
Yeah.
There's a series of findings at paragraph 171. In terms of the facts, we adopt those. Mr. Williams challenges them, but I'll leave that as a matter for him. And then over the page at 175 is where it goes wrong. .4 and 175.5. As to causation, given the DJ's findings about the claimant's dishonesty, the claim would have succeeded in part had the matter gone to trial. Therefore, but for the decision to discontinue, AXA would have had to bear its own costs and pay the claimant's costs. And then over the page, paragraph 180 on page 132. When liability is admitted and the claimant is honest, in most cases the claimant will succeed. Given the DDJ's findings, AXA is fortunate it didn't have to satisfy a reasonable credit hire claim and pay the costs. And then he pulls the threads together at paragraph 185, identifying factors which are different from the standard credit hire claim, as he puts it. He identifies a number of factors that militate in favour of the non-party costs order: the early admission of liability, the early offer, the commercial benefit of the litigation being limited to the vehicle-related claims, Spectra's general management of all vehicle-related claims. And then he balances that against a single factor that he identifies, which is my client's good fortune in escaping the judgment and costs, which he says would be just not to make an order. Now, we say that he goes wrong here in his analysis, essentially from a causation perspective, that we've had a lucky escape of costs that, but for that lucky escape, we wouldn't have been able to recover. And that's for two reasons. Firstly, he's applying a sort of but-for causation analysis, which, for the reasons we've given, we say is wrong. But secondly, also, the idea that if the claimant had not discontinued, she would have won her claim, and therefore my client cannot benefit from the cost consequences that would usually flow from that discontinuance, we say is an error of law. It is an established error of law when we are just looking at the position as between claimant and defendant. So if you have a position where a claimant brings a claim, discontinues the claim, the default costs order is made, it is not a good basis for the claimant to say, well, I know I discontinued, but I could have pursued my claim to trial, and if I had, I would have won.
Sorry, not a good basis for what?
For the claimant to be allowed to have an order other than that the claimant pays the costs.
Yep.
So the default order under 38.6 is a claimant pays the costs on discontinuance, and saying that if I pursued my claim to trial I would have won, even if the court accepts that, is not a good basis for those cost consequences to be avoided.
And that's Nelson's Yard.
That's the Nelson's Yard and the Brooks and HSBC Bank cases.
Which says you don't do that, you don't speculate.
Well, it's not just that you don't speculate, it goes a little bit further. If I could just very briefly take you to the Brooks case, which was adopted by the Court of Appeal again in the Nelson's Yard case. They're both Court of Appeal cases. Page 395 of the bundle, tab 16. So the central reason is set out in the Brooks case, which is then adopted again by the court shortly afterwards in Nelson's Yard. And it's page 395, tab 16.
Tab, which, sorry?
395,
yeah.
tab 16, Lord.
Yeah, Brooks, yeah.
And then if we come within the judgment of Lord Justice Morbitt, page 397, there's an analysis of the authorities, and then the judge formulates a number of principles which are expressly agreed to by the court. So one, where a claimant discontinues, there's a presumption that the defendant should recover his cost burden on the claimant to show good reason. Number two, the fact the claimant would or might well have succeeded at trial is not a sufficient reason for doing so. Would or might well have succeeded. And of course, in this case, the conclusion was would, but it wouldn't have been a good reason for the claimant to avoid the consequences. And we say a fortiori, it can't be a good reason for the non-party costs order not to be made. And I won't go further for those reasons for present purposes, but just over the page at paragraph 8 we can see where the court says that that is a fair summary of the authorities and the principles.
Yeah.
So we say it certainly wouldn't have been a good basis for the claimant to avoid liability here. As we know, justice points instead towards the non-party. CPR 4416 points towards the non-party. And we say in those circumstances the judge's reasoning was flawed.
Yep.
Would your Lordship, Your Ladyship, give me a moment?
Of course.
Lord, my Lady, we of course rely on the full contents of our Skelton argument. We've set out grounds for the appeal which explain in further detail why we say the judges were wrong, but I've tried to keep it in abbreviated terms for present purposes. Unless there are any questions, those are our submissions on this.
No, thank you very much. Thank you very much, Mr. Manley.
Thank you.
Yes, Mr. Williams.
Yes, thank you, my lord, my lady. May it please the court, our respectful submission is that both these appeals should be dismissed, and we say that on both a narrow and a broad basis. The narrow basis, as the court will anticipate, which is the less important, is that we say both judges in the lower court conducted a mixed exercise of evaluative judgment and discretion, in which they didn't make errors of law and came to rational conclusions, such that on very familiar principles the appeals cannot succeed. The broader and more important basis is that we submit not only that the judges below were entitled to reach the conclusions that they did, but they were bound to. Now, whether we are right or wrong about that is the more important question, because even if in this sort of context it might be fanciful to suppose that this court can devise a one-size-fits-all solution for every possible variant of these multitudinous cases, it may enable the court to at least fashion a one-size-fits-most solution, which, as Mr. Madalou has anticipated, also may significantly reduce the burdens on the lower courts in particular. Now, obviously, that is the more important outcome, and so I'm going to focus for most of my submissions on our broader propositions. At the end, as with Mr. Malulu, I will come to the judgments and make my submissions as to why we say that in any event they are narrowly correct. But the broader propositions, by way of overview, essentially are as follows. Not all of these are disputed, I believe, between Mr. Malulu and myself, but some of them are. First, while this jurisdiction, the NPCO jurisdiction, is both a broad and a fact-sensitive one, it is not a parliamentary justice jurisdiction. It has ultimately to be rooted in principle. And Mr. Malulu has pointed out the obvious unease that Lord Briggs expressed in the Supreme Court, only one of these cases to go to the Supreme Court, being told it's really just about justice and exceptionality. And he actually says at the outset of his judgment, which of course I'll be coming to probably tomorrow, is that his task in giving that judgment is, quote, a search for principle. So one has to try to locate the principles, even if, as my Lord Justice Coulson observes in the shareholder case, the director case, perhaps, my words not his, the most you can hope for is signposts rather than rigid rules. In terms of the search for principle, as I said, aspects of this are agreed. I think Mr. Malulu and I would probably agree that all or almost all of the decided cases can be fitted into one of four categories. The first is the so-called pure funder, the charity or benevolent relative or something of that sort that supports a claim out of benevolence. Well established that in ordinary circumstances no recourse against them, and I need say no more about that. The second category is where the non-party has become a real party. And obviously that is really the focus of this litigation, at least in this court. The third category, where the non-party has intermeddled in the litigation. And the last category, what might broadly be called misconduct cases. And it might be that, for example, the asset stripping sort of cases like Total Liban can fall into misconduct. And that's a very shorthand way of explaining them, not that they perhaps need explaining. One of the distinctive things about misconduct is that in some misconduct cases, the court certainly has not searched for causation, because it's always been accepted that a cost order can, in appropriately extreme cases, simply be imposed as a sanction. But even in the misconduct cases, there is usually causation, which is in fact a point which my Lord makes in the Gochner case, and I'll come to what my Lord said about causation in that case, as I say, either later this afternoon or tomorrow. So of those four categories, intermeddling, pure funding has never arisen, misconduct has never arisen, it's never been alleged. In fact, there's always been a fastidious avoidance, as we've again seen from my learned friend today, of any suggestion that what the business models that we're here examining are in any sense inappropriate or unlawful. Intermeddling was suggested in the lower courts, rejected, and is not renewed. So as to the real party question, now that therefore is what these appeals, the question on which these appeals may turn. Our position on that is as follows. Firstly, we accept that it is obvious that a credit hire organisation has a commercial interest in the outcome of cases like these. It would be absurd for me to try to disown that. Clearly, a cost order, a damages order against a defendant, which in many of these cases is actually an insurance company, because you can now sue them directly under the 2002 regulations that are a part of retained EU law. Or if they are not in fact directly the defendants, they stand behind the defendant because of the compulsory motor insurance regime backed up with the last resort of the Motor Insurers Bureau. It's obviously in the commercial interest of any credit hire provider to look to a solvent, insured third party in place of their customer, who very frequently will not have the resources to pay for hire charges easily, and in the vast, perhaps the majority of cases, at all. or certainly not in any way that would be commercially attractive. I mean, paying them off at £100 a month over 3 or 4 years is obviously not going to be commercially attractive to any provider of hire sources. So we accept that there is a commercial interest, but what we say the cases show is that whilst that might be necessary, it is not sufficient. And we say that when you analyse the real party cases, what they actually show is that to constitute a real party and thereby expose yourself as a non-party to a cost order in connection with any limb of the claim, the position must be that that limb of the claim is conducted in the exclusive interest of the non-party. And that really is one of our key propositions. It is not enough, we say, on the authorities that there is a shared interest. And really, that is perhaps the real. That's really the real dynamic of the dispute between my learned friend and myself. He says a shared interest is sufficient. We say that it's insufficient. And we, in fact, say it's already been clearly decided by the courts that, in fact, a shared interest is not enough. Because when you get to the cases about liability insurers, that's travellers preeminently, it's central to the analysis that the question is, because there's always a shared interest in the insurance cases. As a starting point, insured and insurer are always going to be aligned, at least at the starting point. What the Supreme Court has said in the insurance cases is the radical change that makes the difference, is where the insurer starts running the litigation in its exclusive interest. Obviously, the insurer is only involved in the first place because there's a shared interest. The key test we will submit the authorities show is that for the insurer to be exposed to the non-party cost order there has to be a divergence of interest so that it essentially usurps the insured and acts in its own selfish interest. And we say that is also clear from the other area where there are multiple previous decisions, including decisions of this court, which is the case of the insolvent company whose litigation is maintained by a powerful or dominant director or shareholder, or sometimes a creditor. Dymox was one of those cases, the Privy Council case. That was a creditor. I'll come to the facts of Dymox later. My Lord's case, my Lord Justice Coulson's case of Gokna, that was a case of a dominant director. But my Lord does say that although his Lordship uses the language of directors for simplicity, his observations also apply to shareholders. Now, of course, it is an ex-hypothesized statement of the obvious, that if somebody is the dominant shareholder of the company, if they support litigation by that company, from which the company is expected to gain, they benefit themselves as well. Because that is simply the inevitable incident of them being the dominant shareholder. It's their company, they own it. It exists for them to extract lawful profit from it. In that context also, what the court has said is the point at which you do pierce the corporate veil and you look at the economic reality, is the point at which it is not being run in the company's interests and it's being run in the selfish interest of the creditor, the shareholder, or the director. Now, in some of the cases, the corporate veil could easily be pierced because it in fact transpired that the dominant director or shareholder was acting dishonestly. One of those is the Threlfall case that Mr. Malalou's already referred to. One of them is a case which my Lord Justice Coulson analyses in the Gokna case called System Care, another decision of this court. That's also a case where manifestly matters weren't being run in the interest of the company because they were actually being run dishonestly. A less extreme example is Dymox. The Dymox is a case where the nominal claimants could never achieve any benefit from the litigation because they had already been bankrupted. And the facts were that the litigation was being supported by the creditor in the exclusive interest, probably in their exclusive interest, but if not their exclusive interest, then certainly the exclusive interest of them and the other creditors. Now, that of course gives rise then to another question which I think to some extent divides Mr. Malalou, perhaps not quite so theologically as this divides us, because Mr. Malilou, I think, accepts that there is at least a theoretical shared interest between a credit hire company and a credit hire claimant in the hire element of the claim. But we say that it is much more than theoretical, and that when you come to analyse the decisions on credit hire, including the decisions of the House of Lords, 3 of them, which curiously are not even examined or mentioned in cases like Farrell and Direct Accident Management, you rapidly see it becomes quite impossible to say analytically that these are cases which are pursued in the, even as to the hire claim, it becomes impossible to say that they are cases which are pursued in the exclusive or even dominant interest of the hire company. And if you were to say that in our submission, obviously which I'll attempt to make good, I think this part of my submission probably this afternoon, that would run directly counter both the basic principles of damages and indeed to the triptych of House of Lords decisions. In this context, another point that I want to stress at the outset by way of my overview is we also say that Mr. Malilou's approach to this question with respect misses the point that the true genesis or instigator, to use a word that he has used a number of times, of the credit hire claim, it isn't the claimant's contractual liability to the hire company. With respect, we say that that starts the analysis in the wrong place, and it overleaps the fundamental antecedent point. The progenitor of these claims is not the contractual liability to the hire company, but the claimant's antecedent need for a replacement vehicle. The claimant contracts with the hire company as a personal decision of their own volition to mitigate the loss of use and inconvenience they suffer because their own car has been damaged or destroyed. And that is what leads to this claim. And that is an important point that one mustn't lose sight of, because one can sort of rush into looking at the contractual terms and the limited rights of security, for example, that the hire companies may try to give themselves over the proceeds of the claim, and say, oh, it is the credit hire company's claim. But it misses the point that that is not right. That contract has only been entered because the claimant's own vehicle has been damaged or destroyed, and they have chosen to mitigate their loss. In the case of claimants who are impecunious, not having any other way of doing it, by freely choosing to enter the services they have, that they've contracted for. And so that shouldn't be lost sight of. Now, in that context, however, it is of course fair to say that once they do that, at least in the DAMS case, it is openly recognised that the credit hire organisation essentially acts no win, no fee. And that forms quite a large part of Mr. Malilou's submissions, but it's no win, no fee. So they write off what they don't recover. To put it in a cruder way than he did, they eat what the claimant kills, and that shows it is that they're the real party. But again, we say with respect that that is simply not tenable given the existing state of the law in this country, because it is absolutely clear that providing claimants with no win, no fee services after accidents in the expectation that you will be rewarded out of their compensation if their case is successful, that is not of itself sufficient to mandate a non-party cost order, because if it were, then every firm of solicitors acting on CFAs, for example, in this country, or indeed any barrister acting for a CFA in this country, would be exposed to a non-party cost order, because they too will have provided professional services in the expectation, or very often to impecunious claimants, in the expectation that they will be paid out of the proceeds of the litigation if the claim succeeds. And the difficulty with that, for my learned friend, is that this court has emphatically and repeatedly set its face against any suggestion that helping claimants through no win, no fee agreements can expose a lawyer to a non-party cost order. So unless my learned friend submits that there should be some special privilege for lawyers that is not extended to anybody else, the mere fact that services are provided post-accident, no win, no fee, in our respectful submission, cannot cannot justify a non-party costs order either. For the same reason, the fact that my learned friend has definitely shown through the admissions document and the company reports that DAMS, at least, has a carefully calibrated business model whereby it profits from claims against third-party liability insurers. And I'm not, though there are some nuances and some places where I will be challenging his emphasis or his reading, obviously I accept the broad point that he has shown you, that the commercial focus of the group of companies to which DAMS belongs is to profit out of providing post-accident assistance to claimants. Again, if that was sufficient for a non-party cost order, then again, every solicitor who, at least in a substantial way of business, acts for claimants on no-win, no-fee agreements after accidents would be similarly exposed. And we say that unless, with respect, this court is to say something which has never been said before, that this court gives special treatment to solicitors and barristers, there really is a very difficult point for my learned friend to explain why he gets a non-party cost order against someone who provides a hire car, no-win, no-fee, after an accident in the hope that they get paid out of the proceeds, but not for solicitors or barristers who provide legal services, and in the case of solicitors, fund disbursements often to the tune of tens or hundreds of thousands of pounds. In major clinical negligence claims, perfectly routine for a solicitor's practice to fund hundreds of thousands of pounds in experts' fees, for example, under a conditional fee agreement. Unless they enjoy some special privilege unique to the legal profession, it's impossible, we submit, to understand how it can be the law that they are not exposed to a non-party cost order, but a no-win, no-fee car hire company, or indeed any other no-win, no-fee provider of services is. Now the next point, so that's what we say, that those are going to be our points about real party and the nature of credit hire claims, the nature of no-win, no-fee claims. The last points really I come to by overview are the points about causation, because even if I've been excessively dogmatic, or if I'm signposting submissions that the court will find excessively dogmatic about, for example, what constitutes a real party, we do maintain that there is a freestanding objection to the non-party cost order sought in these cases and cases like them, which is that there is no causation. And can I respectfully remind the court that this is a case where, certainly in the DAMS case, the district judge found as a fact that the defendant, which bears the burden of proving the non-party cost application, had failed to demonstrate that any costs were incurred that would not have been incurred anyway, and there is no appeal against that finding of fact. So my learned friend does not contest the finding of no causation. He merely says causation is something, as a matter of law, his grounds of appeal say, that the judges were not entitled to take into account. And I am forgiving the court if it considers it excessively purple language, but we are going to submit that when you get into the authorities, that really is a hopeless proposition. And the absolute high watermark for my learned friend is the authorities that say the causation may not always be jurisdictionally requisite. There is not a single authority that says anything other than the causation is very important. So we say that here, that in neither case can the defendants prove that costs were materially increased by the credit hire claim. And of course, in the other case, I've said in the DAMS case, there are findings of fact which aren't challenged. In the Spectra case, the findings of fact are perhaps a little bit more murky. But if you just step back, remember this is a case that was discontinued at a pretty early stage. So the proposition, the total cost claimed were only about £3,000. So the proposition that at that early stage there is a sort of distinct seam of costs which you can clearly sort of nail to the mast of the credit hire claim and not to just to the general cost of the litigation. That is not really something that my learned friend has ever seriously contended for. But in respect of causation, we say that in this forensic context, there is an additional and freestanding reason for causation to be a central focus, which is this, these are personal injury claims. The reality is we are here because of quox. Really, it's not a coincidence that both these cases are personal injury claims that have been brought before the court by way of specimens. This is a problem which is arising because of quox. It's also for that reason that between Farrell being decided in 2009 and the series of cases we've had since 2013, such as the cases before Mr. Justice Turner, there's no reported instance of an unparty cost application against a credit hire company. This is a controversy which has developed because quox has come on the scene. Can I just? There are really probably two reasons for that. Firstly, issues about costs particularly arise in credit hire companies that involve personal injury, credit hire claims that involve personal injury. Because the point that can be lost sight of is in the credit hire cases which don't involve personal injury, very often there are no costs orders because a very large proportion of them are on the small claims track. This is what gets you off the small claims track is a personal injury claim, because the financial value for personal injury claims to go onto the cost-bearing tracks is much higher than it is, much lower than it is for non-personal injury cases. And there's a further nuance.
And that's the total value. That's the total value of the personal injury claims that get you off the small claims track.
Well, it's become slightly more complicated in recent years because of cases of which my lady is very well aware, because she, until the Supreme Court affirmed her gave the leading judgment on the issue. The Whiplash Reform Act has now introduced a series of variables, so cases differ depending whether they're whiplash injuries or non-whiplash injuries.
Yeah.
But in broad terms, and certainly from a historical perspective, you only needed to show a personal injury claim with general damages of more than £1,000 to get off the small claims track. And I think in the current state of the Judicial College guidelines, that's going to be really any injury which lasts more than a few days is going to be sufficient to get you off it. So that was the historical position. So that's why these cases have mostly arisen in a PI context. Because a very large proportion of the cases outside the PA context are small claims. The cut-off point, the automatic cut-off point for small claims that are for property damage only is £10,000.
Yeah.
But even those cases can still be allocated to the small claims track as a matter of discretion. And certainly my instructions are that in county courts up and down the country, if it's just a claim for hire charges, whether this is right or wrong, I'm not adopting any position on, but the district judges will say, look, it doesn't make any difference if it's £15,000 or £5,000. The points are the same; they're familiar points of mitigation. I put these cases on the small claims track. So I mean, that's also part of it. The other part of it is, I think I say in my skeleton, is this problem is arising because the defendants can't enforce against the claimants because of quox. These claimants have all got ATE insurance. When Mr. Malilou sort of went through the DAMS prospectus, what he didn't show you was all the sections in it. I'm not criticising him for this; it wasn't part of his argument. But there are sections in it making it absolutely clear that DAMS isn't an irresponsible company. It doesn't expose its claimants to the risk of litigation without insuring them. And it has an after the event insurance division. That's one of the part of the group Mr. Malilou didn't need to ask you to turn up the facts of. So, and when it's and that of course explains why the admissions report talks about the risk of adverse cost orders. Yes, that is a risk because DAMS has also got an ATE insurance division, I'll call it. The point is that the defendants can't get to the ATE insurance because the claimants have got quox. And so it is quox which is leading them to try and divert the case to the credit hire company instead. Now, that's a very long run-up to a very short point. Again, I don't criticise them for doing this, but what I do say is this: it's all very well saying, well, because I can't get at you or your ATE insurance, I'm going to try to get to the hire company. That's all very well and good, but we do say causation comes in here. Parliament has decided that defendants should bear their own costs of personal injury claims, barring certain exceptions like fundamental dishonesty. That is a decision that has been made. So you can well see that there might be circumstances in which potentially justice may say, well, if you come along and you add to a personal injury claim a credit hire claim, and by doing that you, in a more than de minimis way, increase a defendant's expense, that might, say no more than that, that might be scope for a non-party costs order if you can tick all the other boxes. But what we say they just can't do, and this is a causation point but a different one, is they can't say, oh, well, we're going to pass on to you part of the cost we would always have incurred because of the freestanding personal injury claim. Because if they're allowed to do that, they are subverting the policy that defendants bear their own costs in PI claims. And of course, it is also worth remembering, and I hope this isn't an excessively jury point, but it is also worth remembering that that is a policy which has not been introduced with any intention of disadvantaging defended insurance companies. It was the quid pro quo for the Jackson reforms, from which the insurance industry as a whole has greatly benefited, because they no longer have to pay success fees and they no longer have to pay ATE premiums. And if it's not too crude a way of putting it, or too, perhaps I should say too cliched a way of putting it, we say they have to take the rough with the smooth. Insofar as the costs are the costs they would always have faced because of personal injury claim, it is indeed contrary to principle to pass them on to the hire company. Those are costs they simply have to absorb, even if there were any injustice, which for the reasons I've just given there isn't, but even if there were, they've now had over a decade knowing about quocs and will have set their premiums accordingly. These cases should be cases where the only point in contention is whether the defendant can pass on costs additional to the personal injury claim to the hire company. But in neither of these cases has the defendant succeeded in demonstrating a single penny of costs was incurred that they wouldn't have incurred anyway because of the personal injury claim. So that's the freestanding point of causation. And lastly, on these sort of preemptive submissions about what we're going to say about causation, I do say that to the extent it helps anyone here, this sort of rather divisive practice direction, if anything, is against Mr. Manilow, because that I'll come to it, but that practice direction repeatedly uses the term about determining the costs which are attributable to the non-quocs elements of the claim. And it does that in the context of non-personal injury claims brought by the claimant themselves. And it also does them in the context of non-quocs claims brought for the benefit of third parties. In both instances, the practice direction uses the language of what's attributable to those cases. And we say that that too also clearly shows the requirement of causation.
So were you saying non-quocs claim?
Forgive me, my
I didn't
lord.
understand what you were saying. Mr. Williams, I do beg your pardon.
No, it's my, I just didn't hear what you said.
Was it something non-quocs claims? What were you
Not by what I mean is, forgive me, I'm using jargon, so I'm well corrected. By non-quocs claims, I essentially mean cases which are elements of the claim which are not themselves protected by quocs. So, as Mr. Manilow showed you earlier, those really fall into two categories: non-personal injury elements of the claim. So if, for example, a claimant, let's assume it's a claimant who's sitting in his house when it gets hit by an out-of-control lorry. He may have a claim for his personal injury suffered when his roof falls in on him, but he'll also might have a very substantial claim for damages to the house. The claim for damages to the house is outside quocs. But in that case, if the claimant loses, he still gets quocs protection for his personal injury claim, but quocs might be disapplied in respect of the costs attributable to the property damage element. And the other broad exception is the one we're more focused on here, which is cases brought for the financial benefit of a person other than the claimant. There too, we say the practice direction signposts that the costs which may be recoverable in those circumstances are the additional costs attributable to those third-party elements, but not the general costs of the personal injury claim, which would always have been incurred.
So the short point on that is you say attributable must bring with it some sort of causation criteria or analysis.
Yes. whether it's as stark as I would like it to be, or whether it's more nuanced. I mean, certainly what the practice direction seems to, and it refers to a sort of just approach to it. Probably that's a reflection of knowing that most of these cases are reasonably low value. They're being dealt with by very busy district judges, you know, who can't necessarily be expected to carry out the sort of meticulous forensic exercise that any of your lordships, your ladyship, would have carried out as when you were trial judges. The sort of exercise my Lord Justice Coulson is obviously all too familiar with, going through Scotch schedules in the TCC, for example. But we say, well, whatever degree of exactitude is anticipated, the term attributable in and of itself carries with it the concept of causation. And Mr. Manilow just sort of pirouetted above the ordinary English meaning of that word.
Are you going to come back to the practice directions, Mr.
I am, yes. Okay. Yes, I am.
These are, as I understand it, these are your greatest hits before we come to the concept albums.
Well, I think that's a very fair way of putting it, my lord. Albeit I don't think you'd want to hear a concept album that I had composed. So if I can start, if I can move then to attempt an exposition of the nature of a credit hire claim, because that has to form the background which I just unpick somewhat. My submissions on what's a real party, and if I can hopefully make some real progress, if not complete that limb of my submissions by 4 o'clock. So the legal starting point is that when a claimant's vehicle is damaged and in consequence he or she is deprived of its use, that gives rise to a claim in damages for loss of use, irrespective of whether a replacement vehicle is hired at all. And irrespective of whether, if it is hired, it's hired on a sort of cash on the nail basis from Hertz, or whether it's hired from a deferred payment provider or a no win no fee payment provider like credit hire organisations. And we say that starting point in and of itself shows that the hire company does not instigate or create these claims. The claims are there as soon as the claimant's vehicle is decommissioned by accident damage. And the claim will be brought come what may, assuming you can find a solicitor to act on a CFA, because if there's not a claim for hire charges, there's still a claim for loss of use. And as will also be seen when I take you to the law shortly, it doesn't even follow that the claim for damages for loss of use is going to be smaller than a claim for hire charges, because the courts have said that in working out what's an appropriate quantum of general damages for loss of use, the court will have regard to what it would have cost to replace the use on the market. Indeed, it's by no means impossible in some of these cases a claim for loss of use would be bigger, and that, I suppose, is inherent in the proposition which we will see at House of Lords level. The correct analysis of a claim for hire charges is a claim that is brought to recover the cost of mitigating the claimant's personal claim for loss of use. And if you think, for example, about the case of Mrs. Smith, the district nurse in the Spectra case, if she hadn't been able to hire a replacement car, and not only would she have had whatever loss of use and inconvenience she had for not being able to use it for social and domestic purposes, she, I don't think we've got her witness statement in the bundle. I've never seen her witness statement. We say precisely because Spectra doesn't have access to things like that. But if you look at what the judges below the basis they proceeded on, if she can't work as a district nurse, not only does she have a claim for general damages for loss of use and inconvenience, she has a claim for loss of earnings. And she potentially, if she loses her job, which if she's in a hire car for nearly 3 months, because that's how long it takes the defendant to make an interim payment, despite having admitted liability within 5 days. That's the point I'm going to come back to. If she's fired because she can't discharge her duties, she probably has a claim for loss of congenial employment as well. So trying to make those good with references to just a small corpus of authorities about these hire claims. If I can come firstly to the well-known decision of the House of Lords in Lagden, which is tab 9. I mean, one of the reasons why this is a famous case is, of course, because it is the case in which the Leeds Bosch dredger finally met its demise for a second time, as it were. Its legal demise, because it establishes that now damages in tort are not limited if the claimant's losses are augmented by their inability to mitigate because of their own want of means. But there is also just an exposition of the nature of credit hire claims, and if I can just pick up the speech of Lord Nichols at page 299 of the bundle. And what he explains is that paragraph 2, when one person's car is damaged by the negligent driving on the part of another motorist, and the damaged car is economically repairable, the owner of the damaged car loses the use of his vehicle while it's being repaired. In the ordinary course, the damages payable by the negligent driver include, in addition to the cost of repairs, damages for the loss of use of the damaged car. In the ordinary course, the reasonable cost of providing the innocent motorist with a suitable replacement vehicle while his own car is off the road crystallises the amount of loss suffered by him under this head of loss. In practice, it's a convenient yardstick by which to measure the damages payable to the innocent driver for the temporary loss of use of his own car. And then it goes on to explain that in credit hire cases, in fact, you don't lose the use of your car at all, because you get a replacement car from the hire company, and Lord Nichols candidly recognises at the top of page 300 of the bundle that it's essentially no win, no fee. Where you'll say, he says, the credit hire companies do not require the motorist to produce an acceptable debit or credit card in advance up front, nor in practice is the hirer required to pay the hire charges in any other way. So there's a loss of use claim, come what may, even if a hire car isn't in fact hired, and the cost of a hire car is a crystallisation of that claim, whether or not a car is actually hired. So you get that claim come what may. That is then looked at in rather more detail and in more of a historical context by a decision of this court called B and Jensen, which the court will have at tab 14. The report begins at page 379. Decision of Lord Justice Longmore, or the leading judgments given by Lord Justice Longmore. And if
Sorry, just give me the tab again.
Forgive me, my lord, I think I said 14.
14, yep.
So I was going to take it up, if I might, at page 385 of the bundle, not the report. So it's paragraph 15. Now, can I just contextualise this somewhat? So what the discussion here starts is premised on the fact that Mr. B was not liable to pay for the hire charges of the replacement car. Now, the reason for that is because the replacement car was in fact provided to him under a bespoke insurance policy, which entitled him to a replacement car from a credit hire company in the event that he had an accident. So the credit hire agreement in that case wasn't no win, no fee, because the credit hire company was being paid by the insurer come what may. But Mr. B himself didn't have a liability to pay for the hire car. It was simply provided as an insurance benefit. But what Lord Justice Longmore says, it does not follow from the fact that Mr. B was not liable for the hire charges of the replacement car that he cannot recover damages for the deprivation of his use. It may be a question of what the appropriate amount of such damages will be, but if he's reasonably made arrangements for a hire car, there's no reason why he should not recover the cost of hire, whether he's rendered himself liable for the hire charges, and whether or not the actual cost has been paid by him or somebody else, such as an insurer or any other third party. Then they cite Lord Halsbury's, again, I think a very celebrated passage from Lord Halsbury's speech in one of the shipping cases called the Mediana. And this is the case where Lord Halsbury, Lord Chancellor at the time, expresses an almost amusing degree of indignation at the proposition that somebody could say that if they destroyed his chair, they wouldn't have to pay him damages for loss of use if they could prove he wouldn't have sat in it. That's the indented quotation. Suppose a person took a chair out of my room and kept it for a year. Could anybody say you had a right to diminish the damages by showing I do not usually sit in it, or I have plenty of other chairs? The proposition so nakedly stated appears to me to be absurd. And then he makes the point that you would quantify the damages for loss of use of the chair with reference to hire charges. What an arbitrator or jury very often do is to take a perfectly artificial hypothesis and say, well, if you wanted to hire a chair, what would you have to give for it for the period? And in that way, they come to a rough and ready sort of conclusion as to what damages ought to be paid for the unjust and unlawful withdrawal of it from the owner. Here I say the broad principle seems to me to be quite independent of the particular use the plaintiffs were going to make of the thing that was taken, except when you're trying to establish the specific loss of profit or of something that you otherwise would have got, which the law recognises as special damage. In that case, you must show them precise evidence, and by precise evidence. But when we're speaking of general damages, no such principle at all applies at all, and the jury might give whatever they thought was the proper equivalent for the unlawful withdrawal of the subject matter then in question. And then Lord Justice Longmore comments on that and says that really for all those reasons, the contention that it was relevant whether Mr. B actually had to pay the hire charges, those points fall away. So there too you've got a recognition that even if you don't hire a car, in fact if somebody deprives you of your use of your chattel, you have an immediate claim which will be quantified by reference to the cost of hiring a replacement.
But if this is applicable, why go to the trouble of making sure the claimant in these cases has a right, has to pay the hire charges, has to owe you the hire charges?
Well, I suppose the first point is that the fact the claimant didn't have to pay in B and Jensen was an artifact of the fact that it was an insurance benefit, and as you know, the law is the principle of the law is that is that the fact that benefits being provided by an insurance company rather than is something you yourself are out of pocket for is disregarded as behind the curtain, or in the old Latin phrase, res inter alias acta. In cases where it's not provided by an insurer, the claimant does need to show that they've got a liability to pay for the car, and the exemplar of that is the Diamond and Lovell case, where the claimant didn't have to pay for the car because it had accidentally been rented under an unenforceable consumer credit agreement, and the House of Lords held that in those circumstances there could be no recovery because the claimant had had a car for free. So that, I think, is probably the answer to your Lordship's question. Can I also perhaps just so we don't have to go back to Langton and O'Connor, in this case also, Lord Justice Longmore quotes Lord Scott's speech from Langton at paragraph 20, and that again is making the point that you don't have to claim special damages. You can claim general damages, and that claim may be quantified with reference to the commercial cost of hire, come what may. So you've got that at 20. In Langton, Lord Scott considered it useful to return to first principles, and in so doing said that the claim for the cost of having a replacement vehicle could be regarded either as a claim for general damages, in relation to which a fair approach to quantum would be to award a sum based upon the spot rate hire charge for a comparable vehicle, or a special damages claim based upon the cost of hire. The fact the claim can be framed as a claim for either general damages based on the spot hire charge for a comparable vehicle or special damages based on the cost of hire echoes the mediana and shows it is not a prerequisite of the claimant's claim that the claimant should himself have incurred the liability to pay the hire charges. If it's reasonable to have a replacement, the reasonable cost of that replacement will therefore normally be recoverable.
But that wouldn't be the hire charges, because we know that the hire charges are 2 or 3 times higher than the spot rate, so you wouldn't get them by way of general damages.
But but what I'm what I'm hearing, this is obviously I'm framing these submissions for 2 purposes. Firstly, to make good the assertion that I'm going to come to, that the claimant never ceases to be a real party because this is their claim. And also the second point, that when it comes to causation, the defendant is in difficulties because even in respect to the claim for hire charges, there is always going to be a claim. Because if the claimant doesn't hire a replacement vehicle, they're going to be bringing a claim for damages for loss of use. And whilst your Lordship has, with respect, rightly put to me that might be somewhat lower in value, it doesn't mean the defendant isn't going to face any litigation at all. And again, it takes me back to the point I made already. This is a defendant that has failed. These are defendants that have failed to show a single penny has been incurred because of the involvement, such as it was, of direct accident management on the one part and Spectra on the other, than if they had not been involved. So that's what this principle goes to. But my Lord, you're quite right to identify that nuance with respect. So I'm grateful. I was then just going to come, if I might, to the Diamond case itself. And if I could, I was going to show you the speech of Lord Hobhouse at page 293. Because if I can respectfully say so, I'm sure we all know that even by the standards of the House of Lords, Lord Hobhouse was a peculiarly rigorous lawyer, and there is and also gifted with great clarity of expression. And there is a very clear exposition of the sort of basic damages principles in his speech. So at 293, he says, Mrs. Diamond, she was the claimant, was at the time of the accident the owner and person in possession of her car. So this is next to marginal, the paragraph that begins below marginal B. The car was damaged, its value was reduced. This can be expressed as a capital account loss. This loss can be measured as being the cost of making good the damage plus the value of the loss of its use for a week. So again, Lord Hobhouse is there recognising that at the moment the chattel is damaged, a loss of use claim crystallises. It does not depend upon a hire company coming on the scene. Then he surveys the issue about rectifying the damage, which is the passage below letter C. I won't read that out. Then he refers to the fact that the points he's making, this is below marginal D, these questions are liable to arise in relation to any damaged chattel, and have long ago received authoritative answers in cases concerning ships. And he cites some reasonably well-known cases like the London Corporation and the Kingsway. He says those cases also distinguish between the cost of the damage to the chattel and consequential loss to the owner of the chattel, such as loss of revenue. However, even where the chattel is non-profit earning, like Mrs. Diamond's car, there may still be scope for awarding general damages for loss of use. And he also cites the Mediana and two other House of Lords decisions. I mention these cases and the principles they illustrate to demonstrate that persons such as Mrs. Diamond do not have to survive in an environment where the law does not recognise the losses which they may have suffered, and the law is not without principles covering the provision of compensation and assessment. Each case depends on its own facts, but loss of use of the chattel in question is in principle a loss for which compensation should be paid. However, one of the relevant principles is that compensation is not paid for an avoided loss. So if the plaintiff has been able to avoid suffering a particular head of loss by a process which is not too remote as his insurance, the plaintiff will not be entitled to recover in respect of that avoided loss. If the loss has only been avoided by incurring a substituted expense, it is that substituted expense which becomes the measure of that head of loss. And that, my lords and my ladies, is the essence of a case where instead of bringing a loss of use claim, the claimant brings a special damages claim for higher charges instead. The claimant has mitigated his or her loss of use by arranging a replacement vehicle, and their case then crystallises as the substituted expense they have incurred. And then there may be issues as to the measure of that loss, as my Lord Justice Coulson put to me a few moments ago. If the claimant might not recover the full contractual loss because it may be said they had the option of hiring more cheaply because they weren't impecunious, for example. But that is still the prima facie measure of their loss. And so again, when we're asking ourselves, firstly, is this a case where the credit hire company has got the exclusive interest in the claim, even for hire charges? My respectful submission will be no, that is an impossible proposition because it just flies flatly against these principles. The claimant suffers their loss of use. They mitigate it by their free decision to enter a hire contract, and that hire contract then becomes the measure of their loss. None of that, the fact that a third party, because it's a deferred payment arrangement, also then has a commercial interest in that claim prospering, does not mean it is no longer the claimant's claim and they are not the beneficiary. And it also goes to the point of causation, and I know I've already presaged this. If the claimant's got a claim for loss of use come what may, then the fact that it's converted to the special damages claim certainly does not ex hypothesi cause additional expense. It may be possible for a defendant to say, on the facts of this case it has, because it's a case like Mr. Justice's case of Kinderton's, where Mr. Justice Turner finds that Kinderton's have essentially manipulated the claimant into bringing a claim that shouldn't have been made. Or there may be cases where, for example, there are very involved questions about whether or not the claimant was impecunious. But in the vast majority, but unless you can point to some special facts like this and say as a result of these nuances, in fact, the costs of this case have become much more than the cost of the loss of use claim I otherwise inevitably faced. You have not shown causation. And that might be a natural break in my submissions, unless there's any particular point I'm taxed on from behind or by the bench.
Well, how are you doing? I mean, I appreciate you've only just started.
Yes.
But I mean, in terms of where you thought that you would get to.
I think I'm probably approximately where I thought I'd get to. I mean, Mr. Madalou, I think, expected to be done between 2:30 and 3, so he obviously finished. And that's not a criticism, of course, at the upper end of his essay.
Well, that's why I was
Yes.
asking, because I mean, we can carry on for another 10 or 15 minutes if you want, but if you're reasonably on track, we'll pause there.
Well, if it's not inconvenient to the bench, perhaps it might be prudent just to take another 10 minutes or so.
Let's do that.
Grateful.
So look, you can look for a natural break, Mr. Williams, from about 10 past 4 onwards.
And much obliged, my lord, and indeed to the the other members of the Constitution. Forgive me, I preempted this by putting my computer to sleep. I've just woken it back up.
Oh, sorry.
No, not at all. It's my fault for jumping the gun. Yes, and as I say just before leaving Diamond, I'm not going to refer to a further passage in it. I'm not going to refer to a passage about this. But what I do say, and I've to some extent prefaced this in a reply I gave to my Lord Justice Birss not that long ago. But the result in Diamond also shows about as graphically as possible that these cases, subject to special cases like B aside, they do remain the claimant's claim. Because as I say, in Diamond, it's actually the key holding. It's what the case is really about if you read the head note. The House of Lords does find that the hire agreements are invalidated because there's been a non-compliance with the Consumer Credit Act. As it happens, in fairness to the hire company, that wasn't because they were reckless about it. The OFT had told them, no, Consumer Credit Act doesn't apply to your sort of transaction. This court and then the House of Lords successively disagreed with the OFT. And as a result of that, and not only did Mrs. Diamond's hire claim get dismissed, I don't think it's an exaggeration to say tens of thousands of other credit hire cases were dismissed, and there were many insolvencies. And one of the points we're making our skeleton, and again, if it's a jury point, forgive me, but there does seem to be something profoundly incoherent, we submit, about the position of the defendants, whereby they happily say, in the hope of windfalls like in Diamond and Lovell, oh, this damages case is absolutely the claimant's claim. It absolutely turns on the claimant proving an enforceable liability to pay for the hire car. And that's challenged on all sorts of bases. I don't have a note of what the defences say in this case, but anyone that sees these cases will know it's perfectly common for defences to go on for page after page raising issues about whether or not the agreement's enforceable, whether or not consumer protection legislation, like the legislation imposing rights to cancel, have been complied with, whether or not there's any possibility that misrepresentations were made to the claimants before they hired the car. All of that is challenged by defendants day in, day out. And yet suddenly, when they win the claim and they want the costs from the hire company, suddenly, oh, this isn't the claimant's claim. The claimant's just a cipher. It's the credit hire company's claim all along. And we do say, and if it's too purist, forgive me, but we do say it can't be a coherent system of law that for damages purposes this is emphatically the claimant's claim. And everything turns on proving the enforceable liability that couldn't be proven in Diamond and Lovell. But suddenly, when you get to the cost, you can just shrug your shoulders and say, "Oh, we don't need to concern ourselves with black letter law here. The commercial reality is it's the hire company's claim." That is, we say in our skeleton, a fairly naked example of cakeism, if I can use the contemporary jargon. I was going to show you one more passage in Diamond before I leave it, which is towards the beginning of the authority. So it's page 277. This is Lord Nichols's judgment or speech. And the reason I show you this is Lord Nichols does make some sort of fairly vivid points about the adverse impact on claimants personally if they're unexpectedly deprived of their cars. And again, the reason I simply take up your time on that is it takes me back to the submission I presaged as part of my greatest hits, as my lord put it. That really the defendant is starting this analysis halfway through, and the real instigator of this case is that claimant has lost the use of their car and potentially suffers really serious inconvenience, and in some cases loss of earnings as well. And Lord Nichols recognises that. And so, if I can take it up at 277 below marginal D. It's an everyday occurrence. Momentary inattention by a driver results in a car running into and damaging another vehicle. The damaged car needs repair, is off the road for some days. The owner of the damaged car requires a replacement. Many car insurance policies make no provision for replacement if the insured is damaged in an accident. I interpose to say that very much remains the case now, 2 decades later, and in fact, well, over 2 decades later. And in fact, even those insurance policies that do, it tends to be a sort of small runaround. It's almost never a like-for-like vehicle, which if somebody's got a family, for example, means it may not be adequate. So because the car insurance companies mostly don't make provision for replacement cars, so the victim of a no-fault accident has to make his own arrangements to tide himself over. And then he explains that under an ordinary car hiring arrangement, the hirer has to produce the hire charge up front. Usually the amount of money is not large, but for many people it's still a considerable sum to have to find with no certainty it will ever be recovered. The innocent motorist has no clout when it comes to seeking payments from someone else's insurers, and no one would wish to become involved in court proceedings to recover the money from insurers. So there are many cases where innocent motorists make do as best they can. They manage somehow without a car, or borrow one from a relation, or get lifts from friends. Either that, they hire a car and they write off the cost. So it comes about the accident hire car companies are fulfilling a real need. They provide replacement cars and additional services as well. The hirer does not have to produce any money either at the time of the hiring or at all. The hire company pursues the allegedly negligent driver's insurers. The hire company is not deterred by having to bring court proceedings should this become necessary. If the claim is unsuccessful in practice, the hire company does not pursue the hirer, and he says that those are valuable additional services. Now, my lords, my ladies, my lady, I don't read that passage out as a cri de coeur. I'm not sufficiently foolish to think that I will persuade the court that car hire companies are charities and who are simply here to help people out. They've obviously wish to make money out of their post-accident services. As I've said already, that doesn't put them in any different position from many solicitors and indeed barristers and indeed others. But the proposition that the car hire arrangement is not the claimant's claim. It is the claimant's claim precisely because it's what they have to do, it's the expense they have to incur in order to mitigate these problems which Lord Nichols so vividly describes, which are not in general problems that motor insurance enables them to address. And again, I mean, obviously, insurance companies could kill credit hire tomorrow if they wanted to by saying to anyone who has a no-fault accident, we'll provide you immediately with a like-for-like car, exactly the same as your own, at our own expense. And they mostly don't, and we don't criticise them for that. But insofar as there is a gap described in these cases, which the credit hire industry has filled, that's just ordinary commercial behaviour in an economy like ours, to the benefit of claimants. And it emphatically does not mean the claims are not the claimant's claims. They are their claims to mitigate the losses which Lord Nichols describes. So what I was then going to do was come on to Giles and Thompson.
Yeah.
I think that will probably take me more than 10 minutes.
Okay, so shall we come to that tomorrow then? You're comfortable with where you are?
I'm just going to have to do my best, and to the extent that I feel I'm running short of time, as with Mr. Manilow, there are detailed skeleton arguments, and it may be, if the bench will forgive me, I have to compress matters slightly and elusively to my skeleton.
We're not expecting any repeats of what's in the skeleton.
No.
We can read, indeed we have read those for ourselves.
Very good, my lord. Thank you.
Yes, all right. Thank you very much. Well, we'll come back at 10:30.
10:30.
Thank you very much.
All rise, please.